Mic check 1 2.
Good morning. I think we need to start. Our agenda today the first item, inputs by the legal advisor on the responses from the State Security Agency. Do we need to introduce each other? I don't think so. Can I then hand over to the legal advisor?
Good morning, Honorable Chairperson and members and colleagues. Thank you for the opportunity, Chair and members. Chair, with your indulgence, I would like to maybe, before we get to the actual responses, because today we'll be proffering what are our responses to what was presented by the department yesterday, as responses to what is currently before the committee, which is the public participation report, the bill itself, and now the responses from the department. So our input, Chair, today will mainly be our responses to what was presented yesterday. But before we get to that, Chair, with your indulgence and members, I would like to maybe just talk about a little bit about the constitutional context under which we are working in this bill. Because, Chair, in reality, what the committee is doing here is a constitutional undertaking, and therefore must always be consistent with what the Constitution provides. So, Chair, I would start firstly with the issue of vesting of rights on Parliament to make legislation. My apologies, Chair.
Yeah, my apologies. Sorry for interjecting. I thought you were going to also introduce. Are we having other people joining us on a virtual platform? Is this the only legal team presenting before us?
Are you referring to members?
No, I thought we over and above having our learned friend. Maybe there are other legal advisors in the platform. Or is my assumption incorrect?
From, okay.
If I could assist the committee chairperson. So Honorable Harte wants to know if there are any other lawyers, maybe from the department, that are joining us today. So, Chair, we should have online, I cannot confirm if she is online, the state law advisor. Her name is Lisa Naidu. So she would have been the state law advisor that certified the bill. I have been working with Lisa Naidu on the work that we are presenting today, Chair, including preparations before that. I don't know if the legal advisor of the department is around.
Is it a prerequisite?
Not at all, Chair. This is a parliamentary process.
Okay. I think it's answered.
Chair, as I was saying on the constitutionality context, so I was saying, Chair, there is a vesting of rights, which is in Section 44, a right on Parliament to make legislation. This is the issue of making legislation is a legislative preserve. That is in line with what is known in the Constitution as representative democracy, where elected representatives make law, Chair, in terms of the Constitution. That is only limited in terms of Section 44 by the very Constitution. It says when the Parliament is making laws, it must do so in line with the Constitution. So this is the limit, Chair. I won't speak to public participation, Chair, because the committee is already advised on that issue. But I also just want to say the department, Chair, which has brought this executive bill for Parliament to consider, is also bound by the Constitution when it carries its functions in terms of Section 198 in pursuance of national security. The powers granted to the department to do what they are supposed to do in terms of the Constitution is also a constitutional undertaking and can only be done within the bounds of the Constitution, including when the department is interacting with state and non-state actors. It can only do so within the bounds of the Constitution because it would be executing a constitutional duty. So I just thought, Chair, that I needed maybe to put that in context as we are going to present the responses, Chair. Thank you for that indulgence. Chair, lastly about the Constitution. Section 2 of the Constitution, which talks about constitutional supremacy, says that the Constitution is the supreme law of the Republic. All law or conduct that is inconsistent with it is invalid, and obligations imposed by the Constitution must be fulfilled. This, once again, Chair, sets the parameters for all institutions and individuals who are cited in the Constitution, that they can only do what is allowable or what is constitutionally permissible. Nothing more, nothing less. Okay, Chair, so thank you for that opportunity. I just want to get into the responses now, Chair. So we'll start with the first response on the document that was presented by the department yesterday. And their response to monitor. We've noted that response, Chair, because the department seems to agree with it. The second one, we've also noted that, Chair, because the department says it agrees with the proposal. The issue of significant intelligence failure, they've said they agree with it, but they want to replace comply with fulfill. We've noted that, Chair, but it is our view that comply would better suit the context of that definition. However, we'll be guided by the committee during deliberation in respect of that issue. With respect to unlawful intelligence activity, the department has said it agrees with that. However, it wants to replace, or would prefer to replace, unlawful with illegal. In our view, Chair, illegal and unlawful means the same thing, because we can't have something that's unlawful which is legal. And therefore, that would not add value to the definition. And we are of the view, Chair, that unlawful actually suits that definition better. But we note what the department has said there, Chair. We have no other further submissions in respect of that. Fair presentation, department has said it supports that. We've noted that, Chair. In the Oversight Act, which provides for they say that the Oversight Act provides in number 6, the Oversight Act provides for a definition of intelligence that differs from the definition of intelligence contained in the National Strategic Intelligence Act. The response of the department is that they support the definition of intelligence as in JLAB. And they say that definition is consistent with the provisions of the National Strategic Intelligence Act. We've noted that they support that, Chair, with their explanation. In 7, we also note the same. The proper citation of the Constitution was incorrect, and they agree. Number 8, the issue relating to Section 7 to be amended, the functions of the Inspector General of Intelligence in relation to the services. Now, the department is saying the proposal is supported. However, it is proposed that the use of national intelligence structures should be used throughout the bill. We've noted that, Chair, because that is just a minor correction. However, the committee will deliberate on that and will take guidance in respect of the committee amendments in the A list. Number 9, Chair, the amendment of Section 7A, they said that it should be amended to read, the reports of the IG contemplated in subsection F shall contain the findings and recommendations of the IG, which shall be binding. That's the proposal from public participation. The response from the department says the proposal for binding recommendations of the OIGI will expose the OIGI process to legal challenge. It is proposed that where there is disagreement, the minister intervenes, and if that fails, the matter be referred to the JSI for final adjudication. Our view on it, Chair, is as follows. We say, as the law pertains now, the JSI exercises oversight over the services. And it is an institution of oversight which is best placed to ensure the implementation of the recommendations of the OIGI, or including the corrective measures of the OIGI. This is based, Chair, on the fact that the configuration of the OIGI is different from a Chapter 9 institution, which makes remedial action that is immediately binding. And that if you had a view opposed to what the Chapter 9 institution has decided, you would have to take that report on review. Whereas the the oversight report of the OIGI, in the form of the certificate, in terms of the Oversight Act, is sent to Parliament, to the JSI, which exercises oversight directly over the services which have been reflected, or whose recommendation would have been against or for in the oversight report. So we say then, Chair, that we propose that the section be amended in the manner that the services must show cause or provide reasons as to why they have not complied with the findings and recommendations of the IGI. We believe, Chair, that this amendment would enhance the compliance, the necessary compliance with the OIGI recommendations, where the department are actually this could be even truncated within a time period, so that within the period that the report or the certificate has been presented to the committee, that the department, if it has not complied or does not comply with the recommendations, that it must show cause before the JSI, so that the JSI could do what is necessary within the oversight mechanisms available to it in law.
Maybe on that one.
Yes.
What if the JSCI also don't agree with the recommendations of the IGI? Not only the minister. Can you just repeat, putting my clarification in?
Yes, Chair. So, Chair, where there is disagreement, between what the IGI has resolved or recommended, between the minister, the OIGI, and the committee. The need for deliberation, because Chair, the purpose of the certificate oversight report of the OIGI is to test compliance with the law, the constitution and the law, by the services, to ensure that they operate within the services. So if the committee doesn't agree, the committee would also be required in law to show cause why is it that they are coming to a different conclusion to what the OIGI has come to, based on the law.
I was actually saying that the minister and the IGI disagree, and it's brought to us. No, not to us. It's brought to the JSCI. And the JSCI seems to agree with what the minister is saying. I was saying in the way you coined does it cover that sort of a situation?
No, Chair. This is a proposal in an instance where the minister or the executive was not responding to recommendations of the OIGI, which the committee agrees with.
No, I'm covered.
Yes. So I was just going to say that currently there isn't such a provision. It is merely by operation of law that the minister would come and present what their view is, and the committee would use oversight, either way, whether for or against what is the recommendation. Thank you, Chair.
Just for clarity, if I may, it seemed to me yesterday that the minister was saying that if there was an issue within the recommendations, she would try and deal with it, and only then would it come to us. Is that not, because we do oversight over the minister, would that not be our first line responsibility to deal with those sorts of negotiations? I wasn't sure why there was going to be that extra layer by someone we actually oversee. So that's what I found a bit difficult in the proposed structure of the process.
If I was to get in on that one, the minister and the IGI, the certificate comes from the reports of the agency, of the services. So they've got to deal with the first line is for the minister and the IGI before it comes to us.
Thank you, Chair.
Can I just find out the method of the presentation? Should we do it this way, which might make sense to me, because we might forget some of the things. Let's see, would that be the best?
Yeah, no, I support pay as you go.
Okay.
Yeah. So I
And
can
the
then
time,
come in.
we haven't talked about the time. Would 1 o'clock be Monday? We are still doing the same thing, isn't it?
But invited until 5.
Yes, sure, sir. We are.
Invitations are made until 5.
Okay, I mean, suggestions for today. What time do we think?
We're invited.
No, we are still doing the same thing on Monday. So, okay. There we are.
See if we can get finished today. We might have to meet now.
Okay. Honorable Stebe.
We agreed with some of these responses, but those that we want to change, we're going through them now, but we're still going to deliberate them. Is that how we see it? So then we're going through this document and we see if this document comply with legislation, with the high-level review panel, everything. Okay, thank you, Chair.
Honorable, welcome, Honorable Hendricks. Honorable Hadebe.
Thank you, Chair. I think we must not lose sight of the fact that we are making amendments because of we are trying to address some of the challenges that we've experienced. And it's not a secret that even though the law allows the committee to enforce the recommendation, it has not happened for decades. The recommendation that we could not, when I'm saying the committee or us, I'm saying those that were responsible then. So the amendment seeks to ensure that there will be measures in place that will compel even us, even though it's contained within the law. So we must take that into cognizance, Chair, and not say, no, the law as it stands, it's perfect, but we have not been able to do that. So meaning there is a problem somewhere. Hence, I would like to ask whether or not it will be legally permissible to have a time bound as you are proposing. And we must not only look into the recommendations that we don't agree with. It must be all inclusive. Those that we agree with, what then we do so that we ensure that there is action taken to those recommendations. Based on the previous experience that nothing has been done for, okay, not everything has been implemented. I wanted to check whether or not compelling the department to have an action plan of implementing the recommendation is best placed to be included in the act, or it needs certain regulations so that we don't bombard the act with operational matters. How then do we make this law so explicit in order for it to be implemented, given the past experience? Thank you. I'm not sure whether you've captured my question. All right.
You are still on the floor.
Thank you, Chair. Chairperson, I just want firstly to say that before we get to the amendment, from a legal perspective, the failures to hold the executive to account where they exist are not because the law is insufficient. So there are no shortage of mechanisms in law to hold the executive to account. There's the Constitution. There's also the Powers and Privileges Act that sets Parliament almost as a court where Parliament can summon people, including summon documents, to ensure compliance. However, where there is a need, for instance, there is no legal impediment, a direct answer, Honorable Hadam, there's no legal impediment to truncating, using time, the period of responses and implementation of recommendations, because using a time-bound process is an effective oversight mechanism to ensure compliance or to ensure response. So the mechanism of making binding recommendations of the of the OIGI in the manner in which it comes to conclusions using the mechanism of the Oversight Act, it would not be, in my view, constitutionally viable to do so, and equating it to the public protector, which is a Chapter 9 institution, who engages in reports differently to how the the OIGI does in terms of the Oversight Act. But if the mischief we're trying to cure is the fact that the department is not implementing the recommendations, then that's where we should go to try and make that process a bit more efficient, including using time. Thank you, Chair.
Honorable Kolabana.
Through you, Chair, perhaps you could explain what you envisage the consequences to be in what we've experienced over the many years. And there are many excuses why numerous recommendations have not been fulfilled. In many instances, they blame the lack of this particular bill, even though much of it has stayed the same. what do you envisage, and is it possible for there to be consequences? Let us say we give an 8-month or 9-month deadline. You must have implemented these within X months, and that is not done. What would the consequence be? Because we might well see ourselves in the same situation. They go, yeah, well, thanks for that, and walk off. We need to draw a line in the sand, and I think that's what we're all missing, is that ability to do that. I don't know if we have that ability. Thank you.
So thank you very much for that question. Chair, the answer to the question asked is that the constitutional design and the role of Parliament is such that it cannot be the implementer itself. This is why you have institutions in the state and organs of state that implement laws, because the executive, in terms of the separation of powers, is the one that must implement. So where there were recommendations, for instance, relating to criminality, organs of state that deal with such matters, including the NPA, the police, and so forth, the committee could use mechanisms to refer such matters directly for investigation and prosecution. Where it was an issue of a ministerial overreach, for instance, where the minister was exercising powers not granted to her by law, the oversight mechanism within Parliament could then be used to hold the minister to account. So there are various things that could be done within existing law to try and enforce some of the recommendations which have been brought by the public protector.
Can I
Sorry,
just,
by the OIGI. My apologies.
Can I just say that what we are talking about here is the failure of Parliament, of the committees. And I would agree that the legislation is there, it's very clear. It's us as Parliament who fails. Because maybe the committee would say, give us your implementation plan, and maybe the excuses might be we don't have the resources, we don't have this, but it's not the legislation that fails, it's us. We don't hold the executive to account. And we can't start running around trying to put it in the legislation. It's there already. It's just that we make maybe the executive our friends, and can I give to? We are still on the same issue, and I think if we deal with it, then we are going to move very. Okay.
Chair, with all due respect, I'm disagreeing with you. I believe we called the various departments in time and again. We asked for lists, we asked for checklists, which ones have been done, why haven't they been done, and they gave us a litany of excuses. So that's why I'm asking, what could the consequences be? Because we did what I believe to be a thorough job. And I mean, the lists were kept, everything, we were on top of it, but we were simply undermined by the answers. Now, that's why I've asked, what would the consequences be if the committee is undermined in that way and ignored and given feeble excuses about why things are not implemented? That's where I'm going with this.
Okay. Honorable Hadebe?
No, just to add on what Honorable B is saying, I fully concur with her. Because I remember I asked, what is the recourse for failure to implement the recommendation? There's no recourse. Exactly. That is why the departments adopt the laissez-faire attitude, because they know exactly it's just recommendation, there's no recourse. Now, when the high-level review panel brought this matter up, it said we must look into considering whether or not we should make the recommendation, but we're trying to cure the problem. And in doing so, we need to review the legislation to make the implicit explicit, Chair. Hence, I'm proposing that I support the view. When Auditor General, when makes findings, departments are forced to have an audit action plan with time frames and responsible persons to address the findings of the Auditor General. I think we need to come close to such so that we're forcing them to produce something immediately after the certificates have been presented with findings, to say you must have an action plan and responsible persons who will be responsible for these corrective actions, and how long will it take, so that the next certificate, when it comes with an update on why they could not implement 1, 2, and 3. So the legal team must advise how then do we craft, because the intention is to make sure that we are explicit in what ought to be done immediately after the recommendation have been presented before us. And we are proposing that we need to have time bound on implementing this recommendation, and there has to be a plan. So it must be captured in such a way that it's clear and everyone knows what is expected. I think I'm trying to push you to assist us in coining the legislation to include those issues, and a plan to address the recommendations, a time frame, and if at all we can have the recourse if some recommendations are not implemented. Thank you, Chair.
Okay, I've got Honorable Hendricks, but I would say, wouldn't that be for Parliament to do? Because it's going to apply to all committees, not only this one. Wouldn't that be Parliament to give those instructions? Okay, Honorable Hendricks. Are you there? Honorable Hendricks, the floor is yours.
Speaking check, but I think it's online.
Can you unmute? Please unmute, we can't hear you.
President of Anjama.
Try again. Can you please unmute? Honorable Hadebi must raise your hand if you want to talk. You might talk things that are irrelevant. Honorable Hendricks, keep on trying, and then we will be continuing. Honorable Stebe.
Chair, thank you. What was said now is that I concur with everything. But still there were suggestions, and we're busy with the Act. There were suggestions that got relevance to the Act. And that's what we must, that's what we can put in, we must put it in the Act. That's how I feel about it. And the others, there's the measures, and if whether they comply or not comply, that is for the committee to do afterwards. There's something that you don't put it in the Act, but that those that refer to be in the Act, we must do that first. That's how I feel.
There must be consequences.
I think I agree with that. You are still on the floor. Those were House rules, I should think. From here, I think we would just be moving smoothly on the other.
Yes,
So
sir.
you are still on the floor.
No, Chair, I hear honourable members and how they have expressed themselves around the issue of consequences. I simply just want to say, Chair, and again, this is not to go against what members have said, we should go and try and do. The consequences for non-complying members of cabinet, ministers, for instance, for Parliament, because Parliament exercises political accountability through oversight, it can only end there. where the minister, first of all, I must say this, in terms of the Constitution, Section 92, ministers exercise executive power delegated to them by the president. And therefore, the next level of escalation, if the minister was not doing what they're supposed to do, would be the president, who is the head of the executive. Where the president was also not complying, it would be incumbent upon Parliament to then bring the matter to the House, which is the highest decision-making body of Parliament, to politically embarrass the executive for not doing what it's supposed to do. Beyond that recourse, in law, there is no other, Chair. For instance, if we're contemplating criminal consequences for non-action, it is not possible within the parliamentary rules and the design of the Constitution. However, Chair, there have been very creative mechanisms used by other parliamentary committees, including the one that Honorable Hatebe serves on, which is SCOPA. SCOPA, for instance, recently had a memorandum of understanding with the SIU, where they would refer matters for investigation or actioning by the SIU in instances where there was non-compliance. But Parliament itself knows that within the bounds of the law, it can do no more if the recommendations are not, or the investigations that would happen are not happening. So similarly here, Chair, if there were issues of criminality, corruption, and so on within the certificate by the IGI, the committee could have working relationships with the relevant institutions that must deal with enforcing the recommendation, because it cannot in itself enforce. The law just does not allow that. But this is not to go against what members are saying that we could look at in trying to amend the legislation, including the issue of informing the department that it must come up with an implementation plan of the recommendations of the IGI. Within the law, without even changing it, the committee can do that. But we can still go to the legislation, as members are suggesting, to go and explicitly state this in amendment. There is a mechanism to do that, Chair. So I don't know if that satisfies the answer, but that is my answer, Chair, on the issue.
Let's try Honorable Hendricks once more. On the platform, Honorable Hendricks. Still we can't hear you. Okay, keep on trying. I think even our technical people are trying this side. Try from your side, and let's. In the meantime, can you continue?
Yes, Chair. So
I might have missed the way forward. Sorry, Chair.
I understand it to be we get the report and we deliberate. Must we do it at the same time? You are giving us a report on on the responses.
yes, Chair.
Is it the right time for us to say we want it this way and not that way? Or do we simply clarify?
Chair, it's just for clarifications on what you are saying are our responses now. Soon after we've done that, it's going to be deliberations where we will be taking instructions about how to go and change the law to reflect what the committee wants to see.
Okay, you answered. So we are now listening to the legal advice on the responses. We are going to take decisions on after we have got. So I think now we can just clarify where that's correct. You are still on the floor. Honorable Hendricks, keep on trying if you manage.
They're trying to sort it out because it's here, the way that we can't hear him. Otherwise, outside is audible. So they're trying to fix it.
Okay. Immediately, Honorable Hendricks, the IT is busy here. If we get through, I'll come over to you. So Skafelapi, you are still on the.
Thank you. Thank you, Chair. So we are on number 10, which is the issue of designating the the OIG to the IGI to go and look into a specific matter on behalf of the committee. So currently the only institutions that can do so is the executive chair, the president and the minister. And we have proposed that maybe it could be amended to include the committee in terms of section 7, subsection 7C of the Oversight Act. So the SSA's response to that, Chair, is that it is noting that and you will be guided by the JSI. We've also noted their response, Chair. On 11, this is the recommendation for the independence of the Inspector General of Intelligence. High procedure. So number 11 reads as follows. It is recommended that there should be a new provision inserted in the Oversight Act to replace section 7, subsection 12, which should read as follows. The IG may, subject to this act, do and cause to be done all things necessary for the efficient superintendence, control and functioning of the IGI, including the appointment of the persons of the office, including the appointment of persons to the office, and the management of the budget as prescribed. The department has responded in the following manner, Chair. The proposal of the IGI suggests that a third schedule entity, in terms of the PFM, may be established. The HLPR recommended that the establishment of a foreign service and domestic, the establishment of foreign and domestic services. The impact on the budget might not allow the implementation of the independence now as proposed. The department further says the executive authority, being the minister, exercises control and direction over the department to prevent the structure from being referee and player at the same time. Regulations will be drafted to ensure standardization of systems and processes and delegation of authority to both the OIGI and NCOP. So that's the departmental response, Chair. And our response is as follows. Firstly, Chair, we note that it was a specific finding of the HLPR that the IGI must be independent. The relevant finding, Chair, reads as follows. The findings and recommendations of the 2006 review report and the 2008 report related to the IGI are fundamentally correct. So these findings, Chair, are the ones that said the IGI should be independent. So this high-level panel review report finds that it associates or supports those findings. Further, it says, Chair, it was a serious dereliction of duty on the part of the successive ministers of the state security that the recommendations of the said reviews were not taken further, and that the long-awaited regulations governing the function of the OIG have still not been promulgated. It further says, Chair, the OIGI should be established as a separate entity, independent of the SSA or any other successor service with its own administration and budget. So it's the HLPR findings that say so, Chair. So our view is that the committee should follow the findings of the 2006 and 2008 review reports, including what was found by the HLPR in respect of the independence of the IGI. We also note, Chair, that there has been decisions of the Constitutional Court, including in Glenister 2, that spoke about the importance of independence of civilian oversight bodies, which function very similarly to the OIGI. The court said, Chair, it highlighted the importance of independence of the civilian oversight bodies, structural and operational independence, including the management of own funds. And it said that these are the key characteristics of an independent civilian oversight body. And we think this is applicable to the IGI. And we further note, Chair, or state that there are no legal reasons which have been proffered by the department in its responses yesterday, which support why the IGI must continue to operate as an extension of only one service, when in actual fact constitutionally it is required to oversee all of the services. So that's our argument, Chair, in respect of independence and how and why we support it.
Okay, yes. Honorable Hendricks, are you there? Honorable Hendricks, it's your time. Still?
So they fixed it, but still.
Okay, no, we'll keep on trying to get you through. They are busy.
Thank you.
Okay, thank you very at long last. The platform is yours.
Can you hear me now?
Yes, just the volume. Adjust your volume.
Chair, can you hear me?
Very
Chair, thanks for your effort, but I'm not sure whether you can hear me. That the committee and I want to put on the table that I'm aware of the fact that officials who do not carry out their responsibilities when it comes to environmental matters, for example, the NEMA Act provides for those officials to be charged in court and be imprisoned and fined. So I don't know if it is possible to look at that more closely. So that means the security forces, when the IGI findings is on the table, and I would imagine the committee supports the findings, and they don't implement the findings, the NEMA Act provides for them to be charged in court. They can be imprisoned. They can be fined. The first prize, of course, is still to give the IGI similar powers to the public protector. But there seems to be a reluctance to do that. And Honorable Hadebi, continuously expresses his strong objection to give the IGI similar powers to the public protector. So he will obviously resist this to the bitter end, to give the.
Can I protect him? Can I protect Honorable Hadev? I've never heard him saying that anyway. He's protected. You can continue.
Okay, I note your protection. Chair, but I tend to agree with you that when the findings are before the committee, and I heard another honourable member says that the committee has made its best endeavours to get the findings of the IGI implemented, but the officials, the intelligence services, the minister ducks and dives and delays the implementation, and then eventually we forget about it. But I tend to agree with you, Chair, that the law allows the committee to act, and the law does not make the committee a lame duck. Thank you very much.
Thank you very much. I would understand Honorable Hendricks when he says officials is referring to the executive, because we are holding the executive accountable, not the officials. The officials are a responsibility of the executive. I think you were still on the floor.
Yes, I like to conclude, Honourable Chair, that when it comes to the NEMA Act, while we know the executive is held to account, in the NEMA Act, it is the actual official, the director or deputy director whose name is in the box and can be charged. So officials can't hide behind the protection of the executive. So the NEMA Act, the Environmental Act, because environment is so important, they've gone to that great lengths to protect the environment. And why should we not go to the same great lengths to keep the country safe? Thank you, Chair. That is all I have to say. And thanks for the special effort to have my voice heard.
Thank you very much. You were still on the floor. Nati?
Chair, we had just completed the independence of the IGI and stating what our view is there in response. It's number 11. Moving to number 12, it's a new provision that replaces the current one in the GLAB.
In terms of the independence, the high-level review panel on the question of recommendations, it is actually saying it is actually saying, do you have it there? It is actually saying that the recommendations of the IGI must not be binding. Must not be binding.
No, Chair, on page 93, the last paragraph, the report says the 2006 task team report made the following recommendation, page 93, at the bottom. So the report is giving us what the 2006 task team recommended. So the 2006 recommended that the findings of the Inspector General in any investigation or inspection should not be enforceable, but should serve as a recommendation. That was 2006. Now, on page 94, it says, but as far as the panel could ascertain, no action or consequence management took place in response to the IGI's report. This raises the question as to whether the services should be obliged to act on the findings and the recommendation of the IGI, similar to the status of the recommendation of Public Protector. Now, this is the key part. This would need further thought. Remember, in 2006, they said it's not needed, but based on what has happened since 2006 until 2018, they are saying now this needs further thought.
This is what we are doing
Yes,
today.
this is what
okay,
we are doing.
no, I'm clarified.
Yeah.
You're
Night
still on
school
the floor.
law, Chair.
So thank you, Chair. And thank you for that guidance from Honorable Hadel. So I was on the independence, Chair. I don't know if I could move on that.
Yeah.
Okay. So we are on number 12, where the proposal is that the new provision that replaces the current one in the GLAB, it must read, the Inspector General may determine the organizational structure and grading of posts for the function of the office. The department's response reads as follows. The proposal by the IGI suggests that a third scheduled entity be established. The HLPR recommended establishment of the foreign service and domestic service. The impact on the budget might not allow implementation. So these are the reasons of the department, that the high-level panel review report only recommended the separation, and that if the IGI was given the independence, it would have this adverse impact on the budget, which would be impossible to, or maybe may not allow implementation.
Wouldn't we say they gave a different version yesterday when they were presenting their responses. The minister said up to a certain level, meaning that maybe the directors or whatever, meaning that they shifted from this. And maybe if I was to ask, is there any legislation that is done because of funds? I've never heard of it. Maybe I must. You can't say we are not going to legislate because we didn't have funds to do that. I've never. Let me be advised.
Yes, Chair. No, Chair, that is a very important question because, first of all, even before we get to the source of that idea, not allowing because money is not there to do the work, one would need to present an analysis, Chair, which would be the basis on how you arrived at that conclusion. So you would have needed to present to the committee a costing from what is currently pertinent to what is envisaged, and demonstrate how what is envisaged will be detrimental on the fiscals. And I think Treasury is best placed to do that. So. And yesterday, Treasury wasn't.
I don't think you are answering my question.
I'm getting there, Chair.
Okay.
I'm getting there. So no, I was just saying, Chair, when one says that something is unaffordable, it's usually based on an assessment of how this is going to cost and why you're saying it's detrimental and so forth. Treasury usually does that. In any case, Chair, the IGI exercises powers in the Constitution and in the legislation. And the impact on that, Chair, is always the same on the fiscals because the functions do not change. Whether the money is appropriated through Parliament or through ring fencing as the department was proposing. Because the amendment does not add new new functions on the IGI. All that the committee is saying is that in order to achieve efficient operational efficiency of the IGI, you must keep it independent. And in order to enhance that independence, its monies must be appropriated to Parliament. I don't see how, Chair, that makes it an adverse impact on the budget, which will make it unallowable. Because there's no law that says that an entity cannot be created to achieve a constitutional purpose.
Yeah, still I don't feel answered. It's legislation done because there are resources, or is legislation done because it needs to correct something? Because you can't say things must continue that way because there's no money. I don't think legislation, that's why I want to be educated. You don't do legislation, according to my understanding, because you have got money or you don't have money. You do legislation in order to correct something. You can't say people can be arrested even if they kill because we don't have resources, we don't have police to arrest them. Doesn't work that way according to me. So I think it's irrelevant to say that there would be no budget. You would have to look for a budget somewhere in order to correct an anomaly. That's my understanding. That's where I wanted to clarify.
No, thank you, Chair. Chair, I don't disagree with you. Safe to say that legislation is costed for proper planning and implementation, to ensure implementation. Because
it's not the other way around.
Yes, Chair. Yeah. So there is relevance to considering the budget when making law, Chair, but it is not in itself an interdict from creating a law. So Parliament cannot be constrained from exercising its power in Section 44 of the Constitution because there's no money. That's a direct answer, Chair.
No, I'm answered. Hey, but you took time. My dear. Okay, continue.
Chair, on number 13, it reads that Section 7, subsection 11C, should be amended to read, as soon as practicable, after receiving a copy of the report referred to in paragraph A, the Inspector General shall submit to the Minister responsible for the service in question a certificate in which an opinion is expressed on the fair presentation of the report and whether anything done by that service in the course of its activities during the period to which the report relates in the opinion of the IGI. So it continues. The SSA's response to that, Chair, is that it supports the inclusion of fair presentation in that section, and we've noted that, Chair. In 14, we've also noted that the department supports that proposal in section 8, subsection 1B of the Act. In 15, the proposal is suggested that intelligence gathering means, which is the definitions now, Chair, the acquisition and dissemination of relevant and reliable information for the development of intelligence products related to any domestic or foreign opportunity or potential opportunity or threat or potential threat to national security or threats to the advancement or protection of national security. The response by the department is as follows, Chair. They submit that according to the National Strategic Intelligence Act of 1994, intelligence gathering is the acquisition and processing of information which includes correlation, evaluation, and analysis of such information into an intelligence product. Now, they say that the dissemination as per IGI or the supply as per the Act of Surveillance of Intelligence Products to a client or NCOP is a process that follows from intelligence gathering process. So they are just explaining it, Chair, and we've noted the explanation.
Does that mean they agree?
It appears that they agree, Chair, because the explanation does not disagree with what is proposed. Okay. And our view, because we have to respond to what they have submitted, is that we note their explanation for deliberation by the committee, Chair. In 16, it's the issue about apprehension. Confers the powers of arrest. It is therefore unclear whether intelligence members have now been given the powers of arrest. In the absence of an offences provision in the National Strategic Intelligence Act, it remains uncertain on how a contravention will take place. The department says that the word apprehend will be removed or proposes it to be removed and replaced by impede or neutralize. And they further provide a definition, and they say that impede should be defined to include measures taken within the confines of the Constitution and the law to disrupt and prevent any threat to national security from manifesting in a prescribed manner. So that's the proposed definition, Chair. And our view, Chair, is that the issue with that definition was that related to apprehend was the issue of opportunity or potential opportunity. And we thought that the use of those words, Chair, was ambiguous and open-ended. And that we would have advised, Chair, for the department to pronounce itself on why we should continue using those words, and that whether it would be necessary for us as drafters to go and work out better presentation of what it is that they want to do, without using open-ended words like opportunity or potential opportunity, which could be susceptible to a constitutional challenge. Chair, because they are based on discretion, and there is no guidance on how that discretion must be exercised. Chair. So what is potential opportunity is not defined. So if a person comes to mind that is a potential opportunity, would that lead to that person maybe infringing on rights and so on? So that's where, Chair, we spoke about possibly either reviewing that or creating a mechanism to check and balances that kind of provision. And that in relation to removing the word apprehend, we said, Chair, that is noted, and that the proposed definition of impede and neutralize is also noted. But we would be guided by the committee if we needed to go and work out better definitions of those words, Chair, to take out any potential confusion or even negative connotations that could be associated with such wording in legislation.
The words neutralize and impede,
yes, Chair,
are in the National Strategic Intelligence Act. Do we have that? Mm-hmm. Do you have it?
No, they said it's there.
It's definitely there. It is there.
So,
Can we then just...
So can we read that?
There's an answer to it.
But yes,
Context
we definitely have that in.
But I don't know which section. That's true.
Chair, if we may.
The first page of under counterintelligence. Counterintelligence means measures and activities conducted, instituted, or taken to impede and to neutralize the effectiveness of foreign or hostile intelligence operations, to protect intelligence and any classified information, to conduct vetting investigation, and to counter any threat or potential threat to national security. Then can we just say, in relation to that, because it's already legislated, we can't, we refer to that law and then we leave it as it is. Is that possible? Whatever advice?
Yes,
because
sir.
it's already there.
Chair, that is possible. What we would then, Chair, request the committee to indulge us on is to go and look at the context under which it is used here in this bill to see if it's not going to give a different meaning to how it is used in the legislation, just for consistency and to avoid confusion.
I think you will help in doing that. Honorable Step.
Chair, just to get to that, it says here, to impede and to neutralize the effectiveness of foreign and hostile intelligence. Foreign and hostile intelligence. I think, and that's the difference. What you now said, is it applicable in this act that we're busy with? That we must decide. Thank you.
If then we will have to explain hostile intelligence operations. They might even be domestic. Can we just say we will be advised about the context in which our legal advisor will go and look at it and see whether it's applicable in GILA. Otherwise, to discuss it now, we wouldn't get anywhere. You are still on the floor.
Thank you, Chair. So we've noted that Chair will provide advice. On number 17.
So, but just to add, because it says.
I haven't recognized you.
My apology, Chair.
Okay.
Am I?
Yeah.
Can I? Thank you. So I'm saying, reading the definition of counterintelligence, yes, it refers to foreign or hostile intelligence operations.
That's exactly what I said, or hostile might be domestic. So we will have him check the context, whether that context suits. I mean, that definition suits what is intended in GILAP. We will be advised on that one. You are still on the floor.
Indeed, you will, Chair. Thank you. On number 17, we talk about the scope of parties included and excluded in this provision needs to be reviewed. So that's where the bill is proposing that the executive, the judiciary, as well as the legislature should get periodic briefings from the services. So the department's response here is that the purpose of this provision is to create a framework for the periodic briefing of the three arms of the state, the legislature, the judiciary, on a needs basis, and the executive on national security trends impacting the country. So it is envisaged that the judges will get intelligence briefings on security trends. So our view, Chair, on that is that the separation of powers would be a concern, the principle of separation of powers, where the executive functions differently from the legislature and the legislature functions differently from the judiciary. even though there is some level of interdependence in the design of the Constitution. We say in Section 165(2) of the Constitution, it is provided that the courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. And in Section 165(3), it reads, Chair, no person or organ of state may interfere with the functioning of the courts. And then we say, Chair, that the courts exercise a constitutional judicial function, and receiving periodic intelligence briefings may be considered or may give a view of interference with the functioning of the courts. And that the services already periodically brief the executive and the legislature to the JSCI. And to add the judiciary to such might be considered to negatively impact on the constitutionally sanctioned impartiality of the courts. So that's just our view, Chair, that when judges look at matters, they must not have had any prior contact with such a matter. And that to give them briefings on intelligence matters might one day impact them if they have to look at an intelligence-related matter. So it might not necessarily, Chair, pass constitutional muster on the basis of separation of powers, this issue of periodic briefings. And once again, Chair, it appears that the bill wants to have the services brief, for instance, in respect of the legislature, the Speaker of the National Assembly. And yet, Chair, in the Constitution and in the Oversight Act, as well as in the rules, it is envisaged that the services report to the JSCI on behalf of all of Parliament. So I don't know the practicalities, and I was hoping that in responses yesterday it would be explained where it would be practically desirable to bypass the JSCI where the services report to go and brief the Speaker, to whom the JSCI reports for the same function. So so our view, Chair, is that this could upset the principle of separation of powers if it was permitted, and that it might just not pass constitutional muster. That's our take on it, Chair. Thank you.
The session expires. People have virtually locked out.
Are we sure it's from this side? Oh, okay.
So we don't know when we will be.
No, but you just saw it now, isn't it? You are very vigilant. You are very vigilant. It means it started now. Are we sure? Are we fine now?
Yes, we're fine.
Okay. And maybe don't let us not intimidate him. I saw everybody raising your hands whilst he was still talking. So can I, in that order? We are on 17.
Yeah.
Okay.
I'm very uncomfortable with this proposal, this clause. Where is the JSCI in this? Why is there a briefing to these entities? And I'm presuming they're open briefings, because once you've allowed all these people in, there's no control over what's going to get out of that meeting. So I'm presuming the media would be involved and be allowed, because the high-level report did say there needs to be more openness in terms of reporting to the public. Is that what this is? I don't know where this is coming from, but it does seem to cut the JSCI out altogether and create some other entity that is reported to rather than us. So I find it most peculiar, and I agree that pulling the courts in is totally unacceptable. It's as though you're putting pressure on the courts to take certain decisions in certain regard. It cannot be.
You will agree next week. Now you need to clarify. Or this afternoon, okay. Honorable Stebe?
Chair, also on that topic, in clause 2, the current provisions state that to members of the cabinet, premiers, parliamentary presiding officers, and the chief justice. That's what it's saying. It's not saying to go to the judiciary because it is not defined. There is defined chief justice, and yes, it says the judiciary. And judiciary is very wide. Shouldn't it just be the chief justice? Because what law advisor said to us, if you go to judges and everything, it might influence them on future, on decisions that they must take in court.
Yeah.
And that's why it should be the Chief Justice. Thank you.
Thank you, Chairperson. So we are on 18, Chair, which is an amendment of clause 13 of the bill, the civilian intelligence structures. So the proposal is that the civilian intelligence service does not define. So it's no civilian intelligence service, not defined, despite being referred to in the bill. The department's response is that clause 13 will be amended to make provision for any other entity established in terms of the Act. And we've noted that, Chair, the response of the department.
Meaning that even subs and even defense.
Yes, Chair, that's what
Okay.
that's what is proposed, Chair. They say they will simply add it. So the response of the department to civilian intelligence service not being defined is that that definition should be amended to read any other entity established in terms of the Act.
Okay.
To make it right and open, Chair. So we've noted what they are proposing, Chair, there for the committee to deliberate and provide the way forward. On clause 19, which is the amendment of clause 32 of the bill, it says no member of the civilian intelligence service may strike or introduce or conspire with any other member or in continuous, Chair. The suggested amendment of that clause is that no member of the civilian intelligence service may strike or introduce or conspire with any other member or person
Or
to strike.
induce.
Well, so my apologies, induce or conspire with any other member or person to strike, nor may the employer cause the lockout of a member or person. So that's the corresponding in terms of labor laws. That's just the corresponding responsibility of the employer. And the SSA has said that it supports this, and we've noted the SSA's view on it. 20, Chair, number 20, which is the amendment of clause 32, says that the minister must, in the prescribed manner, make provision for internal rules to deal with complaints, grievances, and consultations on conditions of service and human resources within the civilian intelligence service. The suggested amendment there is that the minister must, in the prescribed manner, make provision for internal rules to deal with complaints, grievances, alternate dispute resolution mechanisms, and consultation on conditions of service and human resources within the civilian intelligence service. So the addition there being the ADR process, Chair. The response of the SSA is that it has no objection to the proposals made in this regard, and also says that the existing regulations will be reviewed to enhance consultations and dispute resolutions mechanism.
Sure.
Honorable Korabana.
In this, is there somewhere a deadline? Because when we've had previously, yes, we will review regulations, etc. 5 years down the line, you're still waiting. And I think that should perhaps go throughout. In every area of this is we must give deadlines, because they simply say, yes, we'll do it, but they don't actually mean in this decade. So deadlines to me are crucial. Thank you.
Okay.
Thank you, Chair. So Chair, we are also agreeable that truncating time periods for purposes of oversight is a very good oversight mechanism to achieve efficiency. So we agree with that proposal, Chair. On 21, Chair, of that presentation, it says that NCOP must supply intelligence regarding any such threat or opportunity, because the services must supply intelligence regarding any such threat or opportunity to NCOP. The department's view, the proposed amendment is that NCOP proposes, or NCOP proposed during the hearings, that the proposal in the insertion of Roman letter 2 of supplying intelligence regarding any such threat or opportunity to NCOP. And the department's view is that the bill should make it obligatory, it was peremptory, I suppose they meant, for all the national intelligence structures to supply intelligence to NCOP. We agree with that, Chair. We've also noted it because we thought that, in fact, by operation of law, that should have been the case anyway. 22 deals with the proposal is the deletion of members of cabinet in line with section 4.2a of the Act, which mandates NCOP to interact with cabinet. The response from the department is that cabinet decided that there is a need for the domestic service to provide periodic national security briefings on counterintelligence and domestic intelligence to the three arms of the state, being executive, legislature, and the judiciary, on a need basis. It further says that members of cabinet and premiers are part of the executive. SSA further submits that the conduct of counterintelligence is not coordinated by NCOP. Once priorities have been approved, it is the responsibility of the national intelligence structures to develop the operational plans on which cabinet would need to be appraised. Again, there, Chair, we raise the issue of separation of powers. And we end it there, Chair, for members to consider all the two proposals, but taking into consideration the fact that it might offend the principle of separation of powers in the Constitution.
Now here it's very clear, it's written judicial. Yeah. Okay. Which would be different from what Honorable Stebe said, or the Chief Justice singled out would be different from when you say the judiciary. So now here it's specifically the judiciary, which you said when the three arms of state come in. Okay. Honorable Kola Barnard, followed by Honorable Hadebe, followed by Honorable Stebe. Can I just find out whether Honorable Hendricks, whether you are still there? Okay, just indicate if you are still there.
Chair, it just seems to me, and please correct me if I'm wrong, but never mind the separation of powers, which is obviously a major issue, to include the judiciary here. But there are actually two issues. First, NCOP is cut out completely, whereas it is their job to collate everything. They should surely be the ones presenting. But they're cut out. It only includes briefings on domestic and not foreign. And they say, well, the conduct of counterintelligence is not coordinated by NCOP, but it should be. No. So in all, this entire process here, to my mind, is absolutely incorrect. Am I thinking along acceptable lines here? I'm finding it most peculiar. Thank you.
David?
No, Chair,
Let's deal with this one first.
yeah, I would need further clarity. I'm just thinking on the 2021 July unrest, there was this big hullabaloo whether, did the minister brief so and so? So, just clarify me, taking that into cognizance, and what was the expectation from the public in dealing with this matter, so that we apply our mind correctly. Thank you.
Honorable Stebe?
I just want to come to the, if you look at the current provision, it gives you the standing committee of the JSCI, members, cabinet, premiers, parliament, office, and the chief justice. Now, the proposal is to get members of cabinet out, and then if you go to the response, and I think what we need to look into is that this is applicable, should just be applicable to one sentence where NCOP is not recognized, because it's on counterintelligence. And they keep counterintelligence separate from, it's not it's a specialist function. And I think that's why they keep, if there's something that relates to counterintelligence, that's why they don't take NCOP in here. And maybe we must deliberate on that, whether that is the right thing to do or whether it's not. And if we can't find amongst ourselves, then we must ask, why is that? Thank you.
Okay.
No, thank you, Chair. My only comment on that, Chair, is that, as asked by Honorable Hatter, is that one of the findings of the, I think it was Central Africa, Professor Central Africa, who looked at the July 2021 unrest, was the issue of lack of coordination of intelligence. And the only legislative structure recognized in law to coordinate intelligence from all the services is NCOP. I don't know operationally why it is that counterintelligence is not part of the intelligence that's coordinated by NCOP, Chair. So I'm not qualified to comment on that. But my colleague from the department, who's a legal advisor of the department, is sitting there and might be able to assist the committee to give more practical information as to why counterintelligence is not part of coordinated intelligence. Chair, with your permission.
Okay. This is the suggestion by NCOP itself, different from those of the IGI. Okay. Well, you can continue. We will deliberate on this one.
Thank you, Chair.
No, Chair, I requested more clarity because on what the proposed what's this the SSA, what are they proposing exactly here?
No, we are talking. I thought I was clarifying that. Or the proposal, or you mean, no, now I understand you. Okay, as from the proposal of NCOP itself. No,
Yes.
you are right.
Yeah, if I can just get that.
Okay, sure. Okay.
I don't think I'm here. I'm following that question, Chair.
He's actually
Can you please
saying
repeat
he
it?
doesn't understand the proposal of SSA in relation to this. What actually are they proposing?
Yes, Chair, that's exactly what I've said. I also don't understand why they are proposing that counterintelligence should be briefed directly to those three arms of the state and not be coordinated by NCOP. But I said there could be practical concerns which we don't know of, and that my colleague there, Leonard from the department, could give us the practical considerations that were not privy to assist Honorable Hatter.
Honorable Kolabana?
Just to read further, it's not only counter-intelligence. They've included here domestic intelligence, which does fall under NCOP. So they're saying a half a briefing on that and then call in NCOP to do the other. It's a dog's breakfast. It just cannot be. I don't know what they were thinking when they wrote this.
What does the primary or original act saying? The original, what does it say? Okay.
Chair, I just want to firstly, for us to understand what counterintelligence means, in going to the National Strategic Intelligence Act, the definition of counterintelligence. It means measures and activities conducted, instituted, or taken to impede and to neutralize the effectiveness of foreign or hostile intelligence operations, to protect intelligence and any classified information, to conduct vetting investigations, and to counter any threat or potential threat to national security. Now, the proposition, Chair, is that we must delete 42A. Now, what does 42A say? So we go to 42A, Chair, and I'm going to read it out now. Section 4 provides for the establishment of NCOP. And 42A reads, which is the functions of NCOP. The functions of NCOP shall be to coordinate the intelligence supplied by the members of the national intelligence structures, being the three services, to NCOP, and interpret such intelligence for use by the state and the cabinet for the purposes of 1. The detection and identification of any threat or potential threat to national security of the Republic. 2. The protection and promotion of the national interests of the Republic. So I end there, Chair. So the proposal is to delete the members of cabinet in that line.
Okay.
So the proposal is that it must be deleted, Chair. So the department's response to that is that the cabinet's decision is that periodic reports on domestic intelligence and counterintelligence will be given to the executive, the legislature, and the judiciary.
I understand members.
Yes.
I would understand why NCOP would say members. But they shouldn't be deleting members of cabinet. They should be deleting members only, because they must report to cabinet. Members would mean individual, according to my understanding. I think that is what they want to, because they report to cabinet, isn't it? According to my understanding. And if it says members of cabinet, it means individual ministers. Would it be what they want to take out?
Yes, you see the confusion of the word members there. It's almost as if it's individual members of the structures that give intelligence to NCOP, whereas it's the actual structure itself, which is a member of NCOP anyway. Because NCOP is formed of the four structures.
That's why I'm saying then maybe my understanding is it's not that they don't want to report to cabinet, but members might mean individual members, meaning that individual ministers.
Yes.
That's my understanding. Okay, I think we can, you are still on the floor. 23.
Okay, Chair. Well, thank you. So 23.
On the question of whether we can ask the member of SSA to respond, I don't think that will be appropriate. We will be putting him under the bus. What if he says something different from what was presented yesterday? So I think they presented, and today From here on, it's members only. And in any way, I don't like his face. Okay. Okay. On a lighter note. Okay.
Chair, I partly agree with you, but it appears as if there is a need for further clarity on certain matters. I know the chair can't multitask.
Okay, sure.
Thank you.
Sorry about
Yes, I'm saying, Chair, I partly agree with you, but it appears as if as we go along, there is a need for further clarity to avoid using the term "in my understanding." Because your understanding might not exactly be what was intended to be presented.
Can
Can
I just read it?
Yeah,
The
I'm saying,
functions of NCOP. He has just read the
Yes,
functions
I'm
of
saying, Chair,
NCOP.
in that regard, it will be advisable to get those who presented to give us their understanding, so that our understanding is exactly what they presented, not the person who did not present, unless he's privy and he speaks with authority on what was presented. But I don't want us to put him under the bus.
Okay, yeah,
But
no.
there should.
So
there
you
is-
agree with me?
Yes, there is a need for. But no, what I am not comfortable with is to say from here it's only us. Where there is an element of doubt and uncertainty, it will be advisable to get clarity so that we have 100% understanding.
No, I agree with you. But let me just say, the functions of NCOP shall be to coordinate the intelligence supplied by the members of the national intelligence structures to NCOP and interpret such intelligence for use by the state and the cabinet. It's very clear, it doesn't say members of the cabinet, it says the cabinet. So there's no ambiguity in relation to that. That's what I was saying from the National Strategic Intelligence Act. You were still on the floor. Am I surprising you?
Yes, I'm saying, my understanding of it, there are 3 arms of state, which includes the executive. If I were to throw a spanner in the works. So when you're saying state, you must take into account that there are 3 arms of state. Yeah, so maybe I don't want to speak on their behalf. The arm, it's executive, legislature, and judicial. So maybe they thought it's a repetition to include cabinet, because when you're saying brief the state, they are already included. Hence, I'm saying it will be prudent for us to get a clear understanding from the horse's mouth.
Okay.
Honourable
on the
Chair.
floor.
Yes, no, Honourable Chair, thank you very much. I just wanted to propose, Chair, given the time constraints of the process, without rushing through or running roughshod over this process, that perhaps our colleague, who you've correctly pointed out, Chair, should not be presenting, assist with noting the questions, which we will also note, that could be sent to the department for further clarity, Chair, where there is a need for such clarity.
Okay.
Thank you, Chair.
That will do.
Chair, in addition to that, I'd proposed yesterday informal that it would be wise if some of them were to be present on virtually on standby in an event like this. Given the fact that we are still meeting on Monday, can the invitation be extended to them to be on virtual on standby when we come across such questions, just to give clarity so that we don't prolong the process unnecessarily. We don't have time.
Take care. Still on the floor.
Thank you, Chair. I've lost where I was now, Chair.
You are going to 23.
Yes, Chair. Thank you very much for guidance. This one reads, Chair, the proposal is for the amendment of Section 4, subsection 1F, on corruption of members of departments of state by NCOP. The department's response is that intelligence structures are defined in the bill, and it is proposed that departments that have no mandate with regard to intelligence are not given the responsibility. Departments or any entity can be invited to provide relevant information to NCOP instead of being co-opted. The regulation on intelligence coordination will further address the matter, and we've simply noted that response, Chair. On 24, which is the proposal that NCOP proposes that it must be the coordinator with the approval of the minister who must appoint members of NCOP or the support staff referred to in the bill. And the response of the department is that they say the responses provided on IGI is also applicable to NCOP. Members would remember what was proposed by the department for the IGI, that it would be impossible to give it independence, including the issue of appointing its staff, because of the budget implications for it. That's amongst the reasons, Chair. I don't know if Chair would want me to go back up just to read that again, or members have noted it, because they have copies in front of them.
Let me get Honorable Stepe.
There's one difference here. The high-level review panel said that NCOP should be in the office of the president. And that is not the case with the IGI. So despite giving them all that, it should be in the office of the president. That's the difference here. And therefore, I can't see that provided also applicable to OIGI's, what they said, their response is applicable to NCOP.
Okay, still on the floor.
That is true, Chair. We also understood it, as Honorable Stepe has just mentioned, Chair, that the recommendations of the HLPR is that NCOP should be relocated to the presidency. And in the response of the department, Chair, it's not clear why that recommendation is not being taken. So that's just our response to that, Chair. On 25? Thank you, Chair.
Still on 24, okay.
No, so in essence, NCOP and IGI should be treated differently. Because we can't say they must have similar independence, because the report proposes that it should be within the presidents. Is that my understanding? All right. And are we, in terms of what is contained, are they in line with the recommendations, or they have off-ramped completely?
Yes, no, the department's proposal in the bill, Chair, goes against what is proposed in the high-level review panel report. Because the proposal is that the minister must appoint staff and also ring-fence the budget. But that aside, I just want to also restate this thing, Chair, that if it was in the mind of the committee that instead of taking NCOP to the presidency as advised by the HLPR, it would still be within the powers of the committee to decide differently, Chair, for or against the proposal. Because the power to decide the legislation that will finalize here is that vested in the committee. So I just wanted to say that, Chair. But for us, the response didn't make sense because it doesn't address the recommendations of the panel. It simply just says that it must be treated as the same response to the OIGI, which the members have now pointed out shouldn't be the same.
Okay, 25.
If NCOP is located in the presidency, it means it will fall under a ministry in the presidency. I think that's what we need to be mindful of. So it will.
I think you are deliberating.
No, I'm responding to the question of independence. and what is contained in the proposal.
I think that was answered by, that's why I'm saying you are deliberating. Nati answered that, or it's up to this committee to decide otherwise. So if you start asking those questions, it means you are deliberating.
I'm not sure, Chair, whether
I've got the right to suppress you.
Yes.
You will do that in the afternoon.
I
Actually,
hear,
you are still on the
I hear you.
Thank you, Chair. Just a proviso, Chair, in what I said, that the informative value of the high-level review panel report and all other reports before the committee are not diminished by my comment, Chair, about the fact that they still inform, but ultimately the power is out of the committee. So in 25, Chair, moving on. Dealing with the proposal is to amend as follows. The coordinator may determine the organizational structure and grading of the posts of the office of the coordinator for the functioning of NCOP with the approval of the minister in terms of the Services, Intelligence Services Act. The department has not provided any comment on this one, and we assume that that's because they still want the issue to be treated like that of the IGI. And our view, Chair, is that there is no legal impediment. So there is no legal justification proffered by the department as to why the organizational structure of NCOP must be determined by the minister of one intelligence structure. So why SSA must be the one that continues to determine the circumstances there as proposed. On 26, Chair, it is proposed, NCOP proposes that the budget of the Office of the Coordinator shall be appropriated by Parliament as part of the budget vote of the intelligence services and shall be expanded in accordance with the rules and procedures set out in the PFMA. The department has responded by saying that SSA does not have a budget vote. The budget of the SSA is appropriated under the National Treasury. It is proposed to ring-fence the NCOP budget similar to that of the IGI. And our view is that to enhance the operational efficiency of NCOP and to ensure that it's independent from other national intelligence structures, its budget may be appropriated by Parliament. So here, Chair, we are simply just relaying the issue that Parliament would still be able, if in its application of the mind, it believed that it would enhance the independence of NCOP to appropriate the monies to Parliament rather than through National Treasury as proposed by the department. And in our view, Chair, the difference to the fiscus is not clear why it would be different if it was ring-fenced and when it is appropriated, because it would be funding the same functions based on APPs and so on, which are conditions for approval of financing. But that's just our view, Chair. The committee will deliberate on it and give us instructions.
Would I be right to say that that is what is happening with iPad?
Yes.
Oh, okay.
That came as a result of a constitutional judgment that talked about the operational efficiency that comes from independence of these kind of institutions. Thank you, Chair. So in 27, Chair, it's a definition of cybersecurity. The bill proposes the insertion of a definition of cybersecurity in the National Strategic Intelligence Act.
Just a minute. Honorable Hendricks, are you in? And is your hand up? Okay, indicate if you can go through.
26, so we are on 26, Chair and members. 27, my apologies. I beg your pardon, Chair and members. This is a definition of cybersecurity. The department's view on that inclusion of definition of cybersecurity is that the inclusion of the definition of cybersecurity is in line with the definition that is in the draft cybersecurity bill. And alignment will be ensured in the process. The SSA and not the Department of Justice is drafting the cybersecurity bill. So we've simply noted that explanation, Chair. We offer no legal advice on it.
Yeah.
Honorable Stepper, followed
we've got the same
by
question.
Honorable
She can ask.
Golabana.
Yeah, I'm quite surprised by this because, to my knowledge and dealings with our members in Justice, they are dealing with the cybercrime bill, and it sounds here that it is not a justice bill, somehow been drawn up by SSA, which I'd never heard before. So I'm very surprised to read this.
Honorable Stebe?
Also to say that we were never alluded to the fact that they are drafting
Yeah.
the cyber security bill. It was never mentioned to us in the committee.
Don't you think the last sentence on their proposal is irrelevant? If we deal with it, we'll just be wasting time. It's actually uncalled for. Their suggestion is the inclusion of the definition. Otherwise, it's neither here nor there. Trying to qualify it, according to me, it won't help us in any way, whether they are the ones that draft it or not. But in relation to this clause, what they're actually saying or suggesting is the inclusion of the definition of cyber. Let's just forget about who is doing what and where. If you say, no, it's me, it's like you say, it's me, not justice, and it's irrelevant here. Can we then continue?
Yes, Chair, no, just to agree with what your sentiments on this, Chair. It is not done in legislation development, Chair, that one bill will be subject to another bill. One bill can be subject to an act of parliament which is passed, because bills can always be withdrawn, expire, and so forth. So a bill cannot now introduce something that will be dependent on another bill, or with a promise that it will be correlated or will be linked to a bill that is not yet passed. As members say, they have not even seen the cyber security bill. But what is true, Chair, is that the cyber security function is currently being carried out by the national, by the NCC as a counterintelligence function. Yeah. So to define it, Chair, would be in the context of how it's going to be exercised by the NCC within the current framework, not future legislation. Thank you, Chair. So in respect of 28, Chair, which is the definitional syntax, the syntax of the first two definitions
And
below
what does this syntax mean?
So the response of the department to that grammatical construction issue then is that the definitions of domestic and foreign intelligence will be amended in line with the 1994 National Strategic Intelligence Act. And our view, Chair, is that we could simply just retain what is already there for the two definitions.
Is that not what they are saying?
It appears so, Chair, but in a slightly convoluted manner.
Okay.
In 29, Chair, the security competency test, department is saying security competence assessments will be applied throughout the bill. So what is known as security competence test now, the department is suggesting that it must be changed to be security competence assessments in the bill. It is not explained, Chair, what difference this brings in terms of that. But we simply noted, Chair, that members will deliberate on it in the context of the bill before them. In 30, Chair, the definition of national security. The proposed amendment is that the protection of the Republic's interest, citizens, institutions of sovereignty, that, Chair, which is written there in 30, the department is saying that it supports that proposal. And our view, Chair, in light of the issues raised in public consultation around the definition of national security, is that the committee should consider retaining the definition that is there in the definition and not amend it, as that one which already pertains seems to cover all of the issues that are suggested by the new proposed definition. That's our view on that issue of national security, Chair. But we'll be guided by the committee's view on it during deliberations. On 31, Chair. Sorry, ma'am.
Honorable Hadebe.
Thank you, Chair. So, the response given yesterday, remember, we asked the question and they responded. What is still not satisfactory in the response given? Because I think even the chair was leaning towards supporting. I think the only thing that they are okay, let me just get the response. Yeah.
No, Chair, we are responding to the document that was submitted as responses of the department and not the oral submissions, because the record has this as what is written response to what is proposed. However, we're also reflecting on what the public has told members during public consultation about the problems that might come or the constitutional dangers that might come with the proposed definition of national security. So I just want to read it for members. It reads, national security means the capabilities, measures, and activities of the state to pursue or advance any threat, any potential threat, any opportunity, any potential opportunity. And this is what was said, Chair, to be too open-ended, subjective, and that would lead to ambiguity and potentially abuse because it was too open-ended. So then we said, Chair, our advice is, if you read what currently pertains now as a definition of national security, you would find that it covers all of these things that are listed from A to E without being so open-ended. For the benefit of members, I'd like to read from the Act what is the current definition of national security. If you could just give me a minute, Chair, to go there.
Against the threat of using of force or use of force, and the following acts: hostile acts of foreign intervention directed at undermining the constitutional order of the Republic, Roman figure 2, terrorism or terrorist-related activity, Roman figure 3, espionage, exposure of the state security matters with the intention of undermining the constitutional order of the Republic, exposure of economic, scientific, or technological secrets vital to the Republic, sabotage and serious violence directed at the overthrowing of the constitutional of the Republic. Yeah. The capacity of the Republic to respond to the use of or threat of the use of force and carrying out of the Republic's responsibility to any foreign country and international organization in relation to any of matters referred to in the definition, whether direct from or committed within the Republic or not.
Okay. Okay. So your suggestion is that it covers
Specifically, see, Chair, as now read by Honorable Hadeb, that it's a catch-all phrase to include all of the listed categories in the bill, which is any threat, but now it's qualified there. So our suggestion, Chair, is just to stick with this definition.
Honorable Hendricks.
Yeah, thank you, Chair.
Okay.
Chair, I feel that the definition, that now we are trying to make it specific and not too vague and general, that regime change must be mentioned. As you know, the Minister recently warned us that there's a regime change happening, so this is a reality. And it will continue until they try and turn to apartheid one day. So regime change is very important in the definition. I'd like you to consider it, Honorable Chair.
Thank you.
Maybe let me ask Honorable Hadeb, I think it might be covered in the
Yes,